Check.
The National University of Advanced Legal Studies, Kochi, and the M.K. Nambyar Endowment Trust, we welcome you to the 5th Barrister M.K. Nambyar Law Lecture. To mark an auspicious start to the event, I request the audience to kindly rise for the prayer.
की शक्ति देना मन विजय करे दूसरों की जय से पहले खुद को जय करे हमको मन की शक्ति देना मन विजय करे दूसरों की जय से पहले खुद को जय करे हमको मन की शक्ति देना भेद भाव अपने दिल से साफ कर सके भेद भाव अपने दिल से साफ कर सके बातों से भूल हो तो माफ कर सके, झूठ से बचे रहे सच का दम भरे, झूठ से बचे रहे सच का दम भरे, दूसरों की जैसे पहले खुद को जे करे, हमको मन की शक्ति देना मन विजय करे, दूसरों की जैसे पहले खुद को जे करे, हमको मन की शक्ति देना।
We are honored by all your presence today as we remember and celebrate the legacy of Barrister M.K. Nambyar, an eminent constitutional lawyer and a pioneer in public law advocacy. Sree M.K. Nambyar, an alumnus of the prestigious Madras Law College and the University of London, began his legal career in Bangalore before setting up his practice in the Madras High Court in 1947. He has been associated with several leading constitutional cases, notably the A.K. Gopalan case, the Kerala Agrarian Reforms case, the Kerala Education Bill case, and the Golaknath case, among several others. Barrister Nambyar stands as not just one of the most distinguished legal minds in the history of independent India, but also as a man known for his affable temperament and the broader constitutional convictions that he set into motion.
The M.K. Nambyar Endowment was instituted at the National University of Advanced Legal Studies by Sri K.K. Venugopal, one of India's most eminent constitutional lawyers, in memory of his father. A senior advocate at the Supreme Court of India, Sri Venugopal served as the Attorney General for India from 2017 to 2022. A respected legal statesman, he helped both Nepal and Bhutan draft their constitutions and has appeared in various high-profile cases, including the dismissal of the Karunanidhi government, the National Judicial Appointments case, and the Babri Masjid demolition case. He has also assisted the Supreme Court as amicus curiae in the 2G spectrum allocation scam case. For his contributions, Mr. Venugopal was conferred the Padma Bhushan in 2002 and the Padma Vibhushan in 2015. The endowment aims to promote public law scholarship by awarding a gold medal in constitutional and administrative law, offering financial assistance to students, and hosting this annual memorial lecture by distinguished jurists.
We now invite Professor Dr. G.B. Reddy, Vice-Chancellor, the National University of Advanced Legal Studies, Cochin, to deliver the welcome address. Sir, we request you to address the gathering.
Honorable members of the Academic Council, the invited Honorable Justices in office and former judges, the respected faculty members, dear students, and more importantly, the members of the family of Sri K.K. Venugopal, Senior Advocate, and the members of the Endowments Committee of Nuals, Kochi. Today is a very auspicious day for the National University of Advanced Legal Studies, because today is the day when the 5th Barrister M.K. Nambyar law lecture is going to be delivered by a very eminent lawyer, judge, author, and in fact a person who contributed to the administration of justice in more than one way, that is Sree Dama Seshadri Naidu garu, Senior Advocate, Supreme Court of India, and former judge, Andhra Pradesh, Kerala and Bombay High Courts. And reminiscing the contribution of such great personalities like Barrister M.K. Nambyar and Sri K.K. Venugopal and many more in the portals of National University of Kochi is a momentous occasion for all the faculty members, the invitees and the students. And we are happy that within a week of the visit of the Honorable Vice President to the Nuals campus, the university, which already planned this law lecture by Honorable Sree Seshadri Naidu garu, is arranging the 5th lecture today about the contribution of Sri M.K. Nambyar and his family. I am not here to explain, our students have already mentioned it. But at the same time, the original thoughts contributed by Sri M.K. Nambyar, which is an acknowledged fact that even basic structure theory owes its origin to the argument advanced by Barrister Nambyar ji in A.K. Gokulam, not necessarily Keshwananda Bharati, reminds us about the historical contribution made to the administration of justice. And I take this opportunity to extend a very warm welcome to all the invitees on behalf of National University of Advanced Legal Studies, M.K. Nambyar Trust and the Endowments Committee of the University, to the speaker, today's speaker, Sree Dama Seshadri Naidu garu, Senior Advocate, Supreme Court of India and the former Justice. And I also extend a warm welcome to all the members of the Executive Council, the General Council, the Academic Council, former Vice-Chancellor, the Advocate General, State of Kerala, the State Attorney, and the other eminent and distinguished invitees. And I deem it to be a great honor and privilege to be a witness to this momentous occasion. And we are very eager to listen to the speaker, Sree Seshadri Naidu garu, because we have an exciting expectation right from the works of Samuel Rutherford to Sir Edward Coke to A.V. Dicey to the modern jurists. So I don't want to stand between the respected speaker and all of you. I extend once again a warm welcome to all the dignitaries and to the speaker, sir. Thank you so much.
Gracious words and for setting the tone for this evening's discourse. It is now a distinct honor to introduce the speaker for the evening, Senior Advocate Sri Dama Seshadri Naidu.
Sri Dama Seshadri Naidu is a senior advocate practicing before the Supreme Court of India. Originally from Andhra Pradesh, he began his legal career in 1997 after graduating from Sri Venkateshwara University, Tirupati. He was elevated to the bench in 2013 and has previously served as a judge of the High Courts of Andhra Pradesh, Kerala and Bombay. He is also an eminent author who has authored various law books, such as the Law of Stamp Duty and Registration in Andhra Pradesh and the Andhra Pradesh Education Code, among others. He is widely recognized for his integrity, clarity in judicial writing, and contributions to the legal education and reform. His current practice spans constitutional, commercial, and administrative matters, and his work continues to shape legal thought and access to justice in India. We request you, sir, to kindly come forward to the dais.
It is also our pleasure to call upon Senior Advocate Sree K. Gopalakrishna Kurup, Advocate General for the State of Kerala, onto the dais to felicitate Mr. Naidu. Thank you, sir. We now invite Senior Advocate Naidu to deliver the 5th M.K. Nambyar Law Lecture on the topic, The Rule of Law, the Foundational Principle or a Fragile Promise.
Judge, High Court of Kerala, the respected Vice-Chancellor, Sree G.B. Reddy, Sree Justice Sree Jagan, the former Vice-Chancellor and my elder brother, Sree Gopalakrishna Kurup, the learned Advocate General, High Court of Kerala, Sree Gopal Pillai, the respected EC member, Sree Manoj Kumar, my friend State Attorney, Sree Unni Krishnan, another friend of mine, and the Senior Government Leader. I hope that's the position he holds. If it has changed, I don't know. And the brilliant faculty of this university, because I could know the names of those who are present here. I may be excused that I couldn't take out their names. And the other dignitaries of the august gathering, as well as I underline my fellow students. Good evening to all of you. It is indeed homecoming for me. I was here for about 5 years before I left the place. Though I left the place, I haven't left the habits. Just a while ago I was telling the Honorable Vice-Chancellor, perhaps I am the only person in Delhi who regularly, under all circumstances, wear mundu. When I was transferred to Mumbai or Bombay High Court, nobody knew I am from Andhra Pradesh, because they didn't know this Naidu or whatever. They thought that even a Kerala could be a Naidu. So invariably they cited before me only Kerala High Court judgments. I tell you a funny incident before I get into this one. One day in Mumbai, a lawyer was arguing before me. He's in his mid-40s. He's a brilliant lawyer, it seems, because he argued very well and he articulated very well. And about 45 minutes into his arguments, some final hearing, I asked him, I didn't know his name until then. I asked him, are you a Carolite? He was taken aback. He said, sir, how would you tell that? I said, anyway, please tell me. He said, sir, I was born and brought up in Bombay only. But my parents hailed from Kerala. But please tell me, sir, how did you place me to be a Carolite? Please forgive me, all of you. He said in his arguments, oil. Instead, we say oil. Then I said that word Kachiyam. Because each region has a distinct way of pronouncing. Neither right nor wrong. I only said my association with this wonderful place. And when I was asked by my elder brother, Sree Jagan, when he was at the helm of the affairs of this university, that I should be addressing, it was sheer audacity on my part to agree for that one. And he reminded me. I kept on postponing until I couldn't say no, because then the present dispensation put me on terms. Either you come over here or face the consequences. I eventually agreed. That's why I am here. And who am I going to talk about? And then before that, who is the person that occasioned the whole event for the last 5 years, because this is said to be the 5th annual memorial lecture? Mr. K.K. Venugopal. As once Shakespeare has described, Cleopatra, neither age nor custom could still make her stale. So is the case with Mr. K.K. Venugopal, the former Attorney General. And yesterday, he was, though online, arguing and defending a constitutional institution. And the vigor is no less in his approach. Unfortunate though, I do not have any direct acquaintance with that living legend. Like generations of lawyers, I too got inspired and at times tried to imitate him. And that is the person who instituted, it seems, this memorial lecture. Who does it concern about? Well, it's an understatement if I say that it concerns his father. It concerns a legend forever, that is Barrister M.K. Nambyar. You pretty well know, it took about 299 brilliant brains of this country to frame the Constitution. It all began with 399 members of the Constituent Assembly. And with the division of the state country into Pakistan and India, 100 were left out, and eventually it was 299. And then from 1950, it has been put to test. I say, many made it, but a few molded it. Especially from 1950 to 1975. That's when Ms. Nambyar passed away. Those 25 years are the formative years in the life of the Constitution. In psychology, there is a term called tabula rasa. That means clean slate. In 1950, the Constitution was a clean slate. And mind you, the statute, the hallmark of any statute is precision. And on the contrary, the hallmark of constitution is its imprecision. It's an organic instrument. If you compartmentalize that, if you freeze that and etch that into the rock, it never grows out of it. That's why the very purpose is, it is loose-ended. Take Article 21, hardly 1.5 sentence. And it has spawned such much of jurisprudence. So that way, this tabula rasa, clean slate, was put to test by way of interpretation. And those molders, who are a handful, at least in the first 3 decades, they included the judges of the constitutional courts. Please remember the words of Justice H.R. Khanna. He once said, "Judges bask in the reflected glory of advocates' brilliance." And we always say that Supreme Court has propounded basic structure theory. And that theory was propounded by a lawyer. And the Supreme Court has accepted it. And the rest is history, as you say. And who is that lawyer? Was it floated for the first time in Keshwananda Bharati? No. In the early 50s, it is Barrister M.K. Nambyar who had that one. And he caught hold of the seed from a German professor who came over to India then to address a student gathering. You know, most of our thoughts are historical accidents. And why did this German professor spoke about, or rather warned, that no parliament should have unbridled power to legislate, including constitution, because of the experience in that nation just before Second World War. And please remember, Hitler got elected democratically and ruled according to law, killed millions of people. He did follow the law, but he did not follow the rule of law. That's our topic today. Well, for the starters, I have given to the Honorable Vice-Chancellor a 50-page handout which could be circulated. And that being the case, I may not bore you by reading page after page. I'll run through whatever are my ideas, either my own or borrowed or copied. I own them. And then we'll have a sort of a session where we can have ideas exchanged. You know, when I was in Kerala, I was quite regular in the Judicial Academy of our High Court. Once I finished my lecture, usually judicial officers captive audience, they will not question us. I used to request them to question me. And I used to carry chocolates in my pocket. I used to tell them, whoever asks me the most absurd question, they'll get one chocolate. You know, safe thinking leads us nowhere. All the development in the world happens because of some absurd thinking. And you call it out-of-box thinking. And once in Kerala, when I was on the bench, one learned senior advocate argued a service matter with regard to a principal sacked in a college without due process. And he cited one judgment. I noted down. He cited another judgment. I noted down. And he cited another. It went on up to 11. I was noting down. Then I felt that it's time I should tell him that that's enough. So then what I did, I told the learned senior, Mr. Senior, articulating a proposition is like writing a sentence. Then citing a question of law, or citing a citation or a decision is like underlining it. If you keep on underlining, the sentence will disappear. Then he said, yes sir, I got it, and he stopped there. So I also said, the brilliance that attracted me in Kerala High Court is the advocate's preparedness. And you ask any advocate with 3 years practice, he will belt out 500 to 1000 case law. And I've seen one advocate stands up and says, this is the latest case law on the point. And the other one stands up and counters that, no, millets, yesterday it was overruled in Supreme Court. That's the preparedness. But I told them, it's all very good, but think original. Right? So, you always, as young minds, think original. Now let me come to the brass tacks. When it comes to the brass tacks, I put a few questions. Sorry. Yes. They are, who governs us? It is too long for me for my comment. Yeah, I can have this. Who governs us? By what means we are governed? And how the governing happens. In a democratic polity, these are the questions that form the foundation for any adjudication. Constitutionally, statutorily, even otherwise, common law. And let me answer that. We govern ourselves. That is democratic republic, what we are. And the next one is by means of rule of law. I have not used the expression constitution for the reason England has no constitution. So to run a government, to run a nation, even on the fairest principles, you don't need constitution, but you do need rule of law. As I've just said, Hitler, popularly elected, and followed the law as it was there at that time. But what happened, you have seen. History's unforgettable catastrophe. Then, how the governing happens? It ought to happen fairly, reasonably, and benevolently. That's how it should happen. Then, what begs the question is, what is fair? What is reasonable? And what is benevolent? All these depend on, say, the culture, the geography, and the history of a nation. If you read history, why did the English people come to us? Because of geography. When the routes of their business were blocked, they chose Silk Route. They came over here. So the whole of common law is simply a matter of colonization. That's how it has happened. Now, having said that one, let me tell you, popularly elected, somebody has all the power in the parliament and not nation specific in any democratic polity. Let's talk on broader terms. instead of putting on silos of this nation or this nation. And they pass laws because they are our representatives, our agents. We have given them the authority. And that law can be enforced. Can you call that into question? Minus Constitution. If you want justification, rather the Parliament wants to, legislature wants to have a justification, it can say that that's the popular will. Lex populi. And who are you to question that one? Does that mean that everything followed as per law still does not pass muster? There is something beyond. And a caveat to all concerned, I am not religious, nor am I irreligious. But I would like to cite two examples from epics. Karen Armstrong once said, "What is myth? Myth is eternal truth put in the context of a story which you call an epic." It's all a matter of our belief. But let me put that story before you. What is law? What is just? What is unjust? Law is amoral. It has no moral content. For example, drinking may be all right today, and tomorrow it's prohibited. It becomes illegal, but it doesn't become immoral. I am an incorrigible storyteller. I am compelled to tell another story. When I was practicing in Mafuzal, we had a nagging doubt. One judge allowed his drink too much. You know, in Tirupati, that's where I hail from, the staple of a young lawyer is money suits. Somebody borrows, defaults, and the creditor goes to court. And when it's going on, the wife, as representing the children, files a pauper suit. We also call it a minor suit in our lingo there, saying that my husband has been addicted to vices, such as drink, gambling, etc., etc. So he has not spent money for the benefit of the family. As a cut of the family, since he has not spent the money for the benefit of the family, it cannot be taken from the joint estate of co-parceling. So that is the plea. So the lady stands usually in the dock, and the creditor's advocate cross-examines her. Chief examination. Those days, before 2001, chief was allowed. In the chief examination, says, "Look, lady," in Telugu though, "Look, lady, your husband has been addicted to vices such as drink." And immediately the judge intervenes and says, "Ask legal questions, not moral questions." Right. Now, I'm at the point of morality, or just and unjust. You know, let me take one episode from Mahabharata. When war was going on, the guru of both Pandavas and Kauravas, Dronacharya, was on a rampage. And Pandavas could not resist their own master. And what's the way to stop him? His only son, Ashwatthama, was the dearest to him. If somebody could tell him that his son befell some danger, say he died, he would be broken-hearted. He would give up the weapons. So who would be the person that could carry the conviction to say that lie? One who hasn't lied up to that. Otherwise you are an inveterate liar, nobody is going to take it for granted. So Krishna, I'm only telling a story, please. So Krishna asked Dharmaraj or Yudhishthira that you better tell this lie. He said, no, I am personification of righteousness. I will not tell a lie. Mind you, until then, his chariot never touched the ground. It was floating in the air because of his righteousness, levitation, at least 3 feet above the ground. Then, Krishna, intelligent as he is, devised another method. Okay, you don't tell a lie. There is an elephant called Ashwatthama. So I asked Bhima to kill that one. And you say, Ashwatthama atha kunjaraha. Kunjaraha means elephant. Right? And he reluctantly agreed. Poor man, pushed to the wall, what can he do? Of all, Krishna himself has said that one. Okay, he agreed for that one. And still he begged him, please, if he hears Kunjaraha, then he won't be throwing it away. Leave it to me, he said, Krishna. So he said in a loud voice, because in the battlefield, Ashwatthama adha Kunjaraha. Then Krishna used his conch. And that last part got drowned. So technically, Yudhishthira has not lied. He followed the law. But is it just law? It's unjust law. Because the moment he said that one, sans all its technicalities, his chariot sank to the ground. If you don't have rule of law, if you have only law, the democracy sinks underneath. That's the moral. Let me tell another example. This is, have you heard about that great Greek tragedian, Aeschylus? He wrote his trilogy. It is called Aristia. He talks about Helen of Troy, the war of Troy, and Agamemnon wanted to reach Troy and conquer it, bring back Helen. And those days, this, I just got that word missing. What do you call the soothsaying? Those days it was very famous. Can anybody help me? The soothsaying, they used oracle. Yes. They used to, all kings used to depend on oracle. Oracle means a man or a woman, priestly person, would have some sort of a Senok experience. There, it's said to be God inhabiting in them. They will tell what should happen, what's good, what's bad, this oracle. So, that oracle told, kill your daughter for success. So, Agamemnon killed his daughter. Went to Troy. You must have watched Brad Pitt, right? Went to Troy, conquered it, came back. His wife wanted to avenge her daughter's death. She killed him. And in turn, their son, right, retaliated and killed the mother. It went on. Then what happened? Then the goddess of justness, they had gods for everything. The goddess of justness, Athena, intervened in human affairs, which was a prescription, and established a court. And what's been said, this is what I have gathered, this paragraph, I will read that one, from the speech of Jonathan Sumption. Have you heard about Jonathan Sumption? Jonathan Sumption is a retired English Supreme Court judge. Earlier he was a historian. And he's such a learned man. He has about 4 books to his credit on law, and also numerous lectures, law lectures, and interviews on the web. Either you can watch or read. Why I said, he is said to be a man with brains wide as the universe. That's how he's called. And this is from Read Lectures. BBC Radio 4 conducts annual Read Lectures. And they are again there online in archives of BBC. Every subject under the sun you can cover. Say, for example, artificial intelligence. The best of the brains have advanced spoke on the topic. And law, people like Jonathan Sumption. So in that one, he talks about this one. And what he says is this. In the final part of Aeschylus' great trilogy, Aristia, goddess Athena justifies her intervention in the world of mortals with these words: let no man live uncurbed by law or curbed by tyranny. Now that was written in the 5th century BC, but the message is timeless and it's universal. Law is not just an instrument of corrective or distributive justice. It is an expression of collective values and an alternative to violence and capricious despotism. This is what I have gathered from this speech. So let me define very shortly what is meant by rule of law. When law meets legitimacy, that becomes rule of law. And in fact, it is so elusive to define. It is many things for many people. It is a justification to do something good, and it's an excuse for some to do bad. So law is always a double-edged knife. It cuts both the ways. And rule of law does the same thing. That's why let's see how it has been defined. It is said to be an exclusively elusive notion, leading to rampant divergence of understandings. A person like Professor Ross has noted a tendency to use it as a shorthand description of the positive aspects of any given political system. Then comes Professor Judith Schuyler. He suggested it might have been meaningless thanks to ideological abuse and gender overuse. Then let me come to Thomas Carothus. He said uncertainty about what the essence of the rule of law actually is. And Professor Jeremy Waldron pointed out that invoking the magic words could mean little more than hooray for our side. And there are judicial precedents which are without number. Take, for example, Lord Steen of English Supreme Court. He said, rule of law enforces minimum standards of fairness, both substantive and procedural. Such authoritative statements cannot be dismissed as meaningless verbiage. And of course, you have got any number of international instruments which have also taken the same path. Have you ever seen statutes incorporating rule of law as an enforceable command, despite its ideological nebulousness or uncertainty? Let me take one example that is of recent origin, if I can say that one. The Constitutional Reform Act of 2005. What it says, it refers to the rule of law as an existing constitutional principle and requires the Lord Chancellor to swear an oath to respect it and judicial independence. Courts cannot deem meaningless a principle deliberately included in an Act of Parliament. Having read this one, I have thought, when it comes to our Constitution, the judicial oath, does it contain any reference to rule of law? Let me check. I have just extracted. I bear true faith and allegiance to the Constitution of India as by law established. This is one instance. And the next one is that I'll uphold the Constitution and the laws. Doesn't have reference to the rule of law. That's what I have noted. Sir, I am not asking one question or one piece of information. What is the length of this speech, sir? How long can I go and bore the people? It's a Friday evening.
Another 25 minutes.
Okay, sir, thank you. Because I just love question and session. Anyway, I've given the handout and that could be circulated to the young minds. Right. Now let me see. What has Lord Bingham said about rule of law? For my lecture, that's one of the seminal books I've relied on. And really, if you want to, it's a moderate sized book. Please read. You gain quite a lot from that one. What he says is, Lord Bingham on his part has defined it thus. All persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly made, taking effect, generally, in the future and publicly administered in the courts. He acknowledges that this is not comprehensive and allows for exceptions, such as in secret trade disputes, and not on that point though here. Now, it echoes, in my view, John Locke's definition as well. He said, where law ends, tyranny begins. Now, let's take some historical milestones. How we have come about. If we stop, in a sense, in the mythological law, I have said about Aeschylus' book. We have an idea when it was written. 5th century BC. 500 centuries before Jesus Christ. And Mahabharata, hoary, difficult to determine. If we come to recorded history, which strikes you as the primary or first document that laid the foundation for rule of law? Any guess? Indeed, Magna Carta. Everybody is nodding. And recently it has completed 400 years. Recently means I'm an old man. Otherwise for you, a little longer. Right? And this is one document. We all feel that laid the foundation. Rightly so. But please remember, it's a document of its time. Why did I say that one? You take the example of Chief Justice Marshall, a brilliant brain, but still, in his time, he supported slavery. He held blacks are incapable of managing their affairs. They are not entitled to holding land. That's why I said, they're all people of their time. Right? And we boast about the saint of Supreme Court. Who? Oliver Wendell Holmes, the junior. In compulsory conscription and sterilization, when it was challenged before the American Supreme Court, he said, one generation of imbeciles is enough. How cruel? Right? That means genetic manipulation, which we abhor now. But they're all people of their time. There's no taking away of their brilliance in the areas they have contributed. Now, with the passage of time, some of them may appear to our modern notions as repugnant. That apart. Why Magna Carta? I just went on this tirade. It was taken by the barons, the feudals, not by the common man. There was no history that it had been applied to a common man on the road. It's a feudal document. But the spirit permeated every written document there afterwards. That's the contribution. If you go to Google and search how many times Indian Supreme Court has quoted Magna Carta, how many times American federal courts have quoted, by one reckoning, American federal courts have quoted more than 1,000 times. So that's one of the documents that has the first ones. You know, among them, in chapter 40, what's been written, you see how relevant it is. Not for Kerala, in some places. To no one will we sell, to no one deny or delay right or justice. Those days, they feared justice would be sold like a commodity. Right? Now, let me come to the next one. That is habeas corpus. What's been said? If there is anything minus written constitution in England, in the UK, and that saved that nation, this one right called habeas corpus, bring the body forth. That's another milestone. Then comes the abolition of torture. If you read English legal history, you could come across star chambers, where the opponents were tortured. It's a legitimate form of punishment. Even until 18th century, rather 17th century, punishments, that's, you know, you have been accused of theft. You are tested by fire. You are asked to extend your hands into the fire. If they are burnt, you are guilty. They invariably burn because physics doesn't know law. It only knows its law. They get burnt and is always punished. Then drowning, even duels. If two people fight, the most honorable way of settling things is duels. Either sword or the gun. And we have moved away from that one. Otherwise all judges must be carrying guns. Then comes the Petition of Rights of 1628. In England, first time in 1628, it was made mandatory that even the king should take an oath that he would adhere to these principles which are akin to rule of law. You know, in 1679, there was an amendment to habeas corpus principle. Why was that? King Charles II had a deputy, right? His chief minister is the Earl of Clarendon. What he was doing, he was taking all the accused, they are accused of treason, rebelling against the king, and he dispatched them to remote islands where this habeas corpus principle doesn't apply. In an arrangement with a foreign nation, they can be sent, friendly nation can be asked to punish them, torture them. That was happening. Then that was corrected through this 1679. Please tell me one recent incident of the same method being adopted by one country. So, US. Which is that instance? Guantanamo Bay, right? That Cuban island, or adjacent to Cuba. What they have done, under US Constitution, without charging, you can't keep a person incarcerated forever. And what they have done to get over, they have dispatched all the prisoners accused of terrorism, plotting against the nation, etc. And there, they were held without any trial, years on end, and that was anticipated in 1679. Then, next comes to Bills of Rights, that's 1689 and 1701. So comes the Constitution of United States, which is the year 1787. And then comes the 10 Amendments. In between is the French Declaration of Rights, that's of 1789. The 10 Amendments came in 1791. You know one funny thing? One of the finest denunciations against press censorship was a pamphlet by John Milton. If it's available online, please read that one. Later, the government appointed him as a censor officer. He was equally ruthless. Right? That's how history has seen. For example, the framers of the American Constitution. For example, Adam. He was the votary. Federalist Papers, you please read, of freedom and free expression. When he became a minister, later became a president, he was again equally ruthless in suppressing them. Power is a different currency. Right. Then, another major step is 1947. What's that? Our own constitution. A milestone. What an amalgamation it is. The best of many, many brilliant aspects. Of course, there are international covenants. We need not touch them. Now tell me, what could be the hallmarks of rule of law? Is it an empty sounding thing? Or there are certain parameters, they need to be followed. So that, for example, you want to be a lawyer, you have to have a degree. To have a degree, you should pass subjects ABC, whatever. So to have rule of law established, what is that you expect from a nation, from a polity? And let me just narrate item by item, not elaborating though, because you could have the notes. One is, the law must be accessible and so far as possible intelligible, clear and predictable. Well, what's been said here? Law must be accessible. I say you have a remedy. To get that remedy, you should deposit ₹1 million. Will you have that remedy? It's a mirage, a myth. Then comes intelligible. You know, once, who as a judge, anybody who could confess privately, nobody, at least in South, escaped the influence of Justice Krishna. I also did not escape. I started writing with treasurer's by my hand. And once I have sent it to a senior judge, because I was on the division bench. He wrote on it and sent back to me, write for the client, not for the professor. Right? So, any enactment must be intelligible. If you write in Greek and keep it there, how is the common man going to have access to it? That's why, whatever be the language, it should be accessible and made available. That's why the hallmark of any legislation, otherwise it will not have binding force, that of publication, the whole fulcrum of administrative law. A rule must be published, otherwise it doesn't bind. It may have been having every other facet. Right. Accessible, then intelligible, clear and predictable. Why predictable? I always used to say, what is the purpose of adjudication? Say a judge. People say to render justice. And I'll tell one anecdote, a very popular one and my favorite one. That is, have you heard about learned hand? Learned hand is a very famous American jurist judge. He was circuit judge. Circuit means there are 13 circuits in US, federal circuits. They are like high courts. District court, circuit court and Supreme Court. That's the TM. Right? He is a circuit court judge and he is the most cited jurist of USA. Next to him is who? Richard Posner. Okay. I am talking about Learned Hand. Learned Hand was a law clerk in the Supreme Court. And they say the only brilliant American Supreme Court judge that never was is Learned Hand. Well, when he was a law clerk, one day I was waiting on the road outside the Supreme Court to reach home or to reach his accommodation. And by then, Oliver Wendell Holmes Jr. was passing by. He hailed and said, "Sir, could you drop me out there? You are the judge." So he said, "Young man, get in." He got in and he was dropped off. So he waved his hand to the judge and said, "Dear Justice, please do justice." And by then, the car went a few paces ahead. And Oliver Wendell Holmes backed up, came out to the place where he was standing. "Young man, what did you say?" He was startled. "Sir, I didn't say anything. I just said, Justice, please do justice. That's not my duty." Indeed. His duty, a judge's duty, is to interpret law faithfully and administer it. Justice is highly subjective, individual notion. Right? And I always believe the purpose of law and the purpose of adjudication is certainty, not correctness. Because again, correctness is a value judgment. What is correct? It's value loaded. So, why it should be predictable? Because if I know, if I do thing A, B follows. This is the predictability. This is the purpose of law. If I depend on my moral notion, my philosophy, my ideology, and I interpret law and I decide, then where is the certainty? Somebody else can. For that matter, England is one country, say for example House of Lords, and then the Supreme Court. The doctrine of precedent is not there. Of course, in 1937 they had a resolution passed, a statement that they should respect it in all circumstances possible. But let me put it this way. They say that the British Parliament is supreme. Once it's supreme, it passes law. And then there is a succession of parliamentarians. Next, another government comes. It's also equally supreme. It simply reverses that law. Next comes another parliament. It simply again does that one. On the principle, it is supreme, nobody can question it, nor can the court. So where is the certainty? So it is not the power that matters. It is not the notion that matters. It is the certainty that matters. All people have to regulate their conduct in line with the law. How does it happen? It happens once they know that their action leads to a particular definable context. This is the hallmark of rule of law. Now let me go to the other one. Discretion. It's a very touchy thing. A.B. Dicey, the sworn enemy of discretion. He fought all his life and he opposed right administrative, that French administrative law which vested discretion in the executive or the bureaucracy. Right? And nowadays, we have traveled too far to say that discretion should not be, it's only the law. Well, what's meant by discretion is a sworn enemy of rule of law, a broad statement on the face of it negative. But you read it down, it has some element of truth in it. That is, discretion within the permissible limits rather than discretion based on individual ideological philosophy. This is what's been avoided. So that discretion is that unbridled discretion. You have seen, because at least my days when I was practicing, when I asked for a bail, and the judge would say, sorry, it's against my philosophy to grant a bail to a person who cheated. Philosophy never matters to me. Right. This is another hallmark of rule of law. Then comes that of, it should apply to all, uniformly. That hierarchy, that hegemony, law scoffs at. Egalitarian society. Unless there is a justification to have stratification, it has to apply across all. Let me see the next. This one. Fourth principle in my submission. The executive and public officers at all levels must exercise the powers conferred on them in good faith, fairly, for the purpose for which the powers were conferred, without exceeding the limits of such powers and not unreasonably. You know, when I was practicing, I'm practicing now, I'm talking about the previous one. When I was practicing, somebody would come to me that, sir, they have not implemented the court's order. Please file contempt. I used to advise them, don't ever do that one. If you do it, they will never implement it in their life. Unless the judge is like Justice Sree. He is the one who never slept until his order is implemented. Not everybody of that fiber. We are somewhat lenient. I used to tell them, you have to coexist. Because sometimes in some quarters, not in the present, in the past, some quarters bureaucrats feel rules don't apply to them. Right? This is where those who administer laws at whatever level should be faithful. Should also be conscious that they are bound by that one. That's why I always used to tell them on the bench, brother, you're not implementing. Please remember, once you retire, your own colleague will not settle your pension papers. Because he feels that he has the power. Right. It's all in good faith. Then, so I've just come to that point. So what are the hallmarks? Good faith, fairness, without any bias, and right to be heard, are altrum partem. Then proper purpose. This is abuse of process. We always confuse two things. Let me clarify. Colorable exercise of power and abuse of power. Please remember, colorable exercise of power is always a question of virus. If a person does not have power to be exercised and he still exercises, it is colorable exercise of power. Whereas a person has the power, but he uses that for an oblique purpose, a collateral purpose, which is not permissible under law. This is abuse of power. So, rule of law is not the ultra-virus theory I'm talking about. This aspect of abuse of power, proper purpose that's been called. Then, not exceeding the limits. Then, reasonableness or irrationality. Then comes judicial restraint. That of reasonableness, in a sense, proportionality. Then comes the next aspect, means to be provided. Which manner the means ought to be provided. And, of course, when somebody could not have the means, alternative dispute resolution is another thing. And having said all these things, I just have to tell what is the role of an individual in the whole scheme of things. I am accusing the government, I am accusing the executive, I am accusing the judiciary. I have not talked about us, ourselves, the consumers of justice, or the law, the common people. And I say, rule of law must also be part of our culture. We have seen, I don't know in our state, say in my state, if a constable, a traffic constable stops, say, a motorbike rider, he will not show his papers, he may have it. He will first say, do you know who I am? And he says, from his immediate SI to the Chief Minister, he will belt out all his names, but he will not show that one. Because we feel it's infratic, below dignity, to answer a legal question. This is the problem. I'll tell you a classic example before I sign off. The rest you can read. That is, once Dhoni, Mahendra Singh Dhoni, began his career. He was a wicket-keeper batsman. In Chennai, there was an one-day international. There, TVS, as a sponsor, had a motorbike, a wonderful sleek motorbike display to be given to the man of the match, then now person of the match. Okay? To be politically correct. To the person of the match. And eventually, it was given to Dhoni. So, the commentators, they were delirious, especially our Indians. They said, now Dhoni, himself being a passionate motorbike rider, that he would go around. So he got onto it, he went around. One player jumped onto it behind him. Another player jumped on it, they went rounds. So our people were telling, our commentators, what a glorious sight to behold there, the young Dhoni who has a lot of life ahead and is been riding with merrily, blah, 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 blah. And the English commentators, England versus India match. Oh dear, look at him, he doesn't have a helmet and 3 people are riding. This is legal culture. Even when police are not looking at us, we should stop at the red light. This is legal culture. And more so, young lawyers, you must be molding your life with that legal culture, because you are going to run this society, you are going to dictate this society, and you are going to have the ultimate purpose of this society. That said, let me end with one favorite poem for the young people. This is by Edgar Guest, an Englishman turned American. A prolific one, but only one poem of his is remembered to this day. That is, It Can't Be Done. Please carefully watch this and Google it and you will find it, have it. Read every day. Somebody said that it couldn't be done. But he, with a chuckle, replied that maybe it couldn't, but he would be one who wouldn't say so till he had tried. So he buckled right with a trace of a grin on his face. If he worried, he hid it. He started to sing as he tackled the thing. That couldn't be done, and he did it. Somebody scoffed. Oh, you'll never do that. At least no one ever has done it. But he took off his coat and he took off his hat. And the first thing we knew, he had begun it. With a lift of his chin and a bit of a grin, without any doubting or quit, he started to sing as he tackled the thing. That couldn't be done, and he did it. There are thousands to tell you it cannot be done. There are thousands to prophesy failure. The dangers that wait to assail you. But just buckle in with a bit of a grin. Just take off your coat and go to it. Just starting to sing as you tackle the thing. That cannot be done, and you will do it. And you will do it whatever is your dream, and that will come true. Thank you very much.
Thank you, sir, for that engaging and thought-provoking address. We now invite Dr. Leena Matthew, Registrar, National University of Advanced Legal Studies, to deliver the vote of thanks.
So you can grill me. What's the easiest thing? Questioning. Please do it. Yes, sir.
It's a wonderful presentation, very erudite and scholarly, no doubt about it. And we have been enlightened with your wisdom. However, some questions I wanted to ask, I noted down for the sake of comprehensiveness. Rule of law and rule of justice or righteousness, whatever you call it. This is a big issue which is going on. And I remember the British and US judges repeatedly made a statement, this court is the court of law and not court of justice. This is repeatedly said. Indian court also started saying, however, Indian courts, but the constitution empowers them also to do justice through Article 142. It says that Supreme Court can pass any order to render justice.
To do complete justice.
Yeah. So this is question number one. Some other questions are, may not be directly...
Sir, first I'll answer this question, I'll go to the next ones. Otherwise, it's difficult for me to digest.
Okay, sure.
Yes, sir. Sir, one thing, there are hundreds of written constitutions in the world. And Indian constitution is the only one which has this expression, to do complete justice. It's a unique one. And surprisingly, when it was framed, literally there was no debate in the Constituent Assembly. It was simply taken at its face value. Now, that's there. So how to tackle it? With all its ideological underpinnings and the difficulties we face. Well, there, justice is, or as understood, in terms of the law prevailing within the panoply of the Constitution. There, the moral notions may not matter, or temporal conditioning may not matter. Because, as I said, truth is eternal. Values must be eternal. So must be justice. And which is the way to have that eternal nature of justice? It should be endorsed in a way that is acceptable. I can't impose my moral notions. If I'm a vegetarian, I compel all of you to be vegetarians. Maybe my moral notion is very good, but still there can't be. Please.
Okay. The next one is about judicial accountability versus basic structure doctrine.
Yes.
The Judicial Standards and Accountability Bill has long been debated but never enacted. It is often said that such a law may violate the basic structure of the Constitution. This is being debated. Is it not contradictory to claim that judicial accountability threatens the Constitution when accountability itself is a core democratic principle? How do we address the public perception that this position appears to protect judges from scrutiny rather than uphold judicial independence?
Yes. First, I'll address public perception. The most dangerous trap any judge faces is public perception. Who tried Jesus Christ? Tushara, can you tell? Who tried Jesus Christ? Pontius Pilate, the Roman governor. He wanted to acquit Jesus. Please remember, he found nothing against him, but the people prayed for his blood. So public perception forced him to convict him. Otherwise, history could have been otherwise. So nowadays, please remember, sometimes judges are afraid of social media because it's faceless. And why people believe social media? Why don't they believe newspaper? Because social media message is sent by your friend or a relative. So it has more belief quotient. whereas newspaper or TV is faceless. You don't know who sent it. So this is the danger of social media. So justice is above public perception. I'll tell you an example. When a famous film star was accused of, in Bombay, of killing one rare animal, and CCTV footage showed that he was in the car alone. But when it comes to circumstantial evidence, it has not added up. Eventually, the learned High Court judge in Bombay High Court, for fear of this backlash, dictated 300-page judgment in the open court. He acquitted him with just reasons. You know what social media said? Even before Google could invent driverless car, this actor had a driverless car, and the car itself killed the buck. So this is the fear of social media. What they don't know is, in common law, an accuser need not disprove the case against him. The burden of proof is on the prosecution. The presumption of innocence is an inviolable principle, barring some statutes where reverse onus is there. So this is another danger we face. And the third one, when it comes to rule of law, doesn't it militate if you don't have judges who are accountable, who cannot be prosecuted, where there cannot be any law to prosecute? Sir, I'll tell you a simple example. Once, I had to defend a plastic manufacturing association in Hyderabad. They are pitted against glass industry. Glass industry has been lobbying, according to him, my client's words, to edge out, to take them away as competitors so that these people can have monopoly. And this plastic industry has said, look, we have got plastics of different types, most of them are safe. What is unsafe has already been banned. So please let us have, because we are providing employment to millions, etc. Having briefed me, the next day I have to argue. While leaving, he told me one thing. Sir, tomorrow you see the newspapers. All newspapers will have headlines about plastic denounced. He said that they feed them, whatever they do, and it will come. Because judges also read newspaper. Right, sir? And that way, you please remember, I am deciding the case as a judge against, say, a powerful man. And he can bring a charge against me. And it can be trumped up. By the time I come out of that, my reputation is lost. My courage to decide independently is lost, because I have to save my skin first. Once you have trusted certain high office and call them constitutional authorities, trust them that they will decide without fear or favor. If you put them on shackles, also remember, what is the basic instinct? That of survival. Survival in body, survival in spirit, survival in form. So that goes. So you'll have, instead of lions on the throne, cats on the throne. Yes, please.
It's a slightly sensitive question I wanted to ask you, probably. A little bit, maybe keeping in their mind for a couple of months. There have been recent controversies such as the alleged recovery of cash from a High Court judge's residence that have shaken public confidence. Often, the argument is made that public criticism of the judiciary undermines its dignity. This is one side of the story. In this context, how can the judiciary win back public trust without being seen as a shielding its own members? Shouldn't transparency and prompt disciplinary action be seen as an enhancing rather than eroding judicial dignity?
Sir, as an answer, I'll tell a story, so that we'll conclude. As an answer, I'll tell a story, sir. So once, in a forest, all trees have very good bonhomie or friendship. They are protecting themselves, they are thriving. They have one elderly tree as their leader. One day, a lorry was coming with weapons. So all young trees ran and told the elderly tree, look, there are people coming with lot of weapons. They may chop us off. They may kill us. Then this elderly tree tells a young one, go and peek into that one. Is there anyone who is our own man in that weapons lorry? It comes and it says, no, don't worry, they can't do anything. The next day, or a few days later, another vehicle. Again it says, see whether any of us or our people have betrayed and gone out there. No, nothing. Eventually, all people ask, every time you tell that one, what is the purpose? How does our man go and destroy everybody? He says, if they get a knife, the handle of knife is wood. If they get a hacksaw, the handle of axe is again. If they have an axe, again handle. So I am part of that establishment. I don't want to wreak damage to it. I refuse to answer.
Okay, any comment on the failure of prosecution in the national or state level where maybe and access to justice?
I don't get you, sir. Please repeat.
Failure of prosecution and access of justice for the ordinary people. It's also the failure of prosecution.
Sir, it is true. You know what happens? If young lawyers, if you read one good book, that's by Jerry Spence. Please note it down. How to Argue and Win Every Time by Jerry Spence. He's into his 90s. He's a legend. In 45 years at one stretch, he never lost a case. In American trial courts, Jerry Spence, 45 years at a stretch, never lost a case. He has defended the world's who is who in American soil, on American soil. Well, and here he says once, say for example insurance companies, in that book he says, they will have well-articulated lawyers defending the insurance company, whereas the poor insurer could not afford the might and match them, and he will have novices, and how could they fare against them? This is in a sense denial of access to justice. That's what he said. Now most of the times free legal aid is there, and free legal aid, who are they? They are just enrolled lawyers with 3 years standing, 4 years standing, etc. Whereas public prosecutors, usually very seasoned ones. So how could you have this David and Goliath story unless it's other converse? Now, yes, it's been identified. Take the example of Supreme Court of India. Now they have put a provision that even senior judges are made available based on the gravity of the case. Sir, it is an evolving process. Trial and error we learn. And that's how ultimately the common man is protected. Please.
So can I?
Why not?
This concept as such, since our basic premise is that
If you ask about concept, basic, you are thinking cleverly. Think absurdly, please.
No, so
Yeah, go ahead. In the right way I say it.
yeah, I know now. The out-of-box thinking is what brings in progress at least.
Please.
So when you speak about rule of law, you have a premise that that law is something that is reflecting the will of the population. That is a premise on which you started off.
No. I have never said it's will of the population then becomes rule of law. I said it's on the contrary.
So you are
Will of the people has. That's what I began with Hitler's episode. He has the will of the people. He has the backing of the people, 90%.
so that was the way in which you tried to distinguish between the majoritarian rule of
Majoritarian rule is no sign that it is a safe one.
So that exactly is the issue. So when you talk about rule of law and upholding of rule of law and it as a foundational principle, if it doesn't really reflect the will of the population, if it doesn't reflect the aspirations of the population, then to what extent is this actually a foundational principle at all?
See, have you finished?
So my point is in relation to that Dhoni example that you gave, because if the people doesn't really appreciate it as something that is so sacrosanct to be upheld, then there is no question of rule of law becoming a foundational principle at all.
I didn't understand honestly what you were saying.
The point is simple. Democracy has to have that reflection. The law has to have a reflection in the minds of the people. So they should have the feeling, that identification with the legal principles of the law as such, as something that is beneficial for them. If there is a disconnect in a democracy, then there is a question of it being appreciated by the people that this is something that is sacrosanct, must be obeyed. Because you can't impose it with state's will. It has to be something that is part of the culture as such.
Good question. You need not obey law because it's sacrosanct. Right? Even if it's sacrilege, if it's law, it needs to be obeyed. I'll tell you, we've had any amount of jurisprudence. Even a void law needs to be adhered to and respected unless it is set aside by a competent court. You know, suppose a void order, void ab initio. Even that void order, you can't self-declare and then say, I'm not bound by it because it's stillborn. That's not rule of law. Even void order needs to be set aside by a competent forum. That's why the principle of disconnect does not apply to enforcement of law. That's what I say. Suppose I love my drink. Tomorrow there is prohibition law. It's a disconnect between me and the law. Can I afford to ignore it? I cannot. So that's why law is immoral. Law is not values. Law is the will of the people as reflected. I'll tell you a simple example. Suppose there is a contract. The divergence, but this is a good question that I would like to answer. There is a contract. And the whole process has been videographed. And eventually contract was signed. Right? And there is a dispute about the contract. What is the intention of the parties? So court has to decide that one. And one of the parties produces that video where the parlays, the discussions happen and eventually sign. The question is, can the judge rely on it and give the meaning to the words? He cannot. The intention of the parties must be taken from the words used there. We say intention of parliament. Is parliament a single person? It's approximation, a sort of a compromise. It's a legal fiction. So what is meant by intention of parliament or intention of parties is the words that have the golden principle, literal interpretation. The words that have been read. Otherwise the danger I'll tell. You two people are aware of what has happened really before the contract was struck. You assign the contract to a third party who had no knowledge about that one. He depends only on the words. So that's why this context of the connect, people falling in love with law never happens. It has an element of coercion. Thank you. Thank you, sir.
Thank you, sir, for taking those questions and enlightening us with your answers. I now invite Dr. Leena Akka Matthew, Registrar, National University of Advanced Legal Studies, to deliver the vote of thanks.
Respected dignitaries and dear students, I would like to propose the vote of thanks for the 5th Barrister M.K. Nambyar Law Lecture 2025. Senior Advocate Sree Dama, Seshadri, Naidu, former Judge, High Courts of Andhra Pradesh, Kerala and Bombay, was kind enough to accept our invite to speak at this lecture. On behalf of Nuals, I thank Sree Naidu for his erudite and inspirational words on the foundational principles of federal and for his quick-fire responses to the questions posed by the audience. Thank you, sir. We have all been anxiously waiting for this lecture. Our former acting Vice-Chancellor, Justice Sree, took the initiative for organizing this event and for contacting Justice Naidu to deliver this law lecture. On behalf of Nuals, I thank you, sir. On behalf of Nuals, I thank the family of Barrister M.K. Nambyar Senior Advocate K.K. Venugopal, and his son, Senior Advocate Krishnan Venugopal, for their support and assistance. On behalf of Nuals, I thank the members of the M.K. Nambyar Endowment Committee, the Learned Advocate General, Senior Advocate Sree Gopal Krishna K, Senior Advocate Sree S. Gokulam and Professor Dr. P. Leela Krishnan, who are actively involved in convening today's event. On behalf of Nuals, I extend my heartfelt thanks to all the other dignitaries assembled here who have graced this event. Justice C.S. Dias, Judge, High Court of Kerala. Sri Manoj Kumar N. Distinguished members of the Executive Council, General Council and Academic Council. The distinguished members of the Bar, including members of the Bar Council of Kerala and the Executive Council members of the Kerala High Court Advocates Association. Academicians, scholars, members of the faculty and staff of Nuals, and the bright young minds who are the focus of this lecture, the students of Nuals and the surrounding law colleges, Government Law College Ernakulam, School of Legal Studies QSAT, and Bharat Mata School of Legal Studies Alwa. This was definitely an enriching session for all assembled here. Thank you.
I now request the audience to kindly rise for the national anthem.
पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
That concludes the formal proceedings for the day. We now invite all attendees to come forward for a group photo.